So let's talk about this concept of California law known as at-will employment. What does that mean? That basically means that an employer may terminate the employee for no reason, for a good reason, a bad reason, a mistaken reason, an unwise reason, or even an unfair reason. The only exception being that the employer may not terminate the employee for a discriminatory or retaliatory reason. Here's a useful quote from a case on this very topic. Quote, "A plaintiff in a discrimination case must show discrimination, not just that the employer's decision was wrong, mistaken, or unwise. The employer may fire an employee for a good reason, a bad reason, a reason based on erroneous facts, or for no reason at all, as long as its action is not for a discriminatory reason. While an employer's judgment or course of action may seem poor or erroneous to outsiders, the relevant question is whether the given reason was a pretext for illegal discrimination. The employer's stated legitimate reason does not have to be a reason that the judge or jurors would act on or approve of." Here's another useful quote that will help you understand how this works. Quote, "What constitutes satisfactory performance is, of course, a question ordinarily vested in the employer's sole discretion. An employer is free to set standards that might appear unreasonable to outside observers and to discipline employees who fail to meet those standards, so long as the standards are applied even-handedly. But that does not mean that an employer conclusively establishes the governing standard of competence in an employment discrimination action merely by asserting that the plaintiff's performance was less than satisfactory. Evidence of the employer's policies and practices, including its treatment of other employees, may support a contention and an eventual finding that the plaintiff's job performance did in fact satisfy the employer's own norms." With all that having been said, please understand that every case is different and the outcome of any case will depend on the specific facts and circumstances of that case. This recording is obviously not intended as legal advice, rather it is intended merely for educational purposes. If you are either an employer or an employee and you believe you may have a case or may require a defense, you should contact competent counsel at your earliest opportunity. You may contact Benjy Law Corporation at 310-203-2650. You are also encouraged to visit our website at www.benjylaw, that's BENJY like yellow, LAW.com for more information. Thanks for listening.